Good morning. This is Rich Sierra. I'm the president and CEO of the Florida Small Business Legal Center here in Boca Raton, Florida. Thank you for listening today to Business SOS podcast. This is episode number 40 of Business SOS. Certainly very excited about, we've been doing this now over 6 months, providing you content and helping business owners how to navigate the treacherous waters of legal problems that inevitably, as a business owner, you will encounter throughout your career and through your journey. I'd like to participate in the show. If you have any legal questions that you'd like me to address in the show, and basically I can not mention your name, I just basically want to answer any questions you might have, send me an email at rich@richsierra.com. And if I select your question and I address it in the show, I'll send you a free copy of my book, autographed, Business SOS, 8 Common Legal Mistakes Business Owners Make and How to Avoid Them. It is available on Amazon, Barnes & Noble. You can ask for your local bookstores as well. So today I want to talk about 5 mistakes to avoid in a mediation conference. Most of the cases, in my experience, and I've been doing this now going on 20 years, most of the business litigation cases settle. In fact, a very small percentage of the cases will go to trial for many reasons. There's a tremendous amount of cost that a business owner will have to incur to be able to take a case all the way to trial. And sometimes many times the cost of litigation exceeds the cost of the controversy. So if you have a $25,000 controversy claim and it's going to cost you $50,000 to take a case all the way to trial, it's not worth it. At some point, someone is going to settle, and business owners, for the most part, make business decisions even when they're facing legal problems because they do a cost-benefit analysis. So, and the reality is whether it's a $25,000 case or a $1 million case, the work that we have to do is exactly the same. In terms of trial preparation, we still got to take depositions. We got to still do discovery. We still answer the complaint. We still have to file motion for summary judgment. It is exactly the same work. And so you don't have a reduction in legal work or legal fees because the amount of controversy is less, because the work is pretty much the same. So having said that, so many of the cases will go to mediation. In fact, in Florida and Broward County and pretty much most jurisdictions in Florida, you're required to attend a mediation conference before going to trial. In some cases, the judge orders a mediation at the beginning of the case, which is my preference. In some cases, they'll order it 60 days before calendar call. Calendar call means is basically checking to see if you're ready to go to trial, and they're going to give you a trial date. By that time, you spend the tens of thousands of dollars in legal fees before you go to prepare for trial, and then you're going to talk about resolving it. My preference is try to get those cases resolved as soon as possible, as soon as practicable, and get a mediation conference in as soon as possible. So briefly, what is mediation? Mediation is a court process to a degree that there are rules of court that govern a mediation conference. But it is a confidential mediation. Let me rephrase. It is a confidential negotiation that is managed by a mediator. It's a neutral party that is either a Florida certified mediator or it could be another party that is basically authorized to conduct mediations. You don't need a license to be a mediator, but it's good to have the certification by the Florida Supreme Court to be a mediator, circuit civil mediator. Could be an attorney, could be a retired judge that retires and decides to pursue mediation conferences. But it's a neutral party, and what that neutral person tries to do is try to bring the parties together and try to find a solution or a compromise to the legal dispute. And I want to emphasize the word compromise, because the reality is that when there's a compromise, both parties will most likely leave a little bit unhappy. One party is going to pay a little bit more than he or she was expecting, and another party is going to receive less that he or she wanted. But there's a benefit to that compromise. And I want to talk about the benefits of mediation. And actually, I mentioned that in my book in page 131 of Business SOS. Actually, 131, it begins, yes, alternatives to filing a lawsuit. And I'm going to talk about what I call the 8 C's of the benefits of mediation. And these are not mine. In fact, I had a mediation about a year ago or so, and a retired judge was actually conducting mediation. He talked about the C's, and I kind of took those and I incorporated into my book simply because it really brings into point why a mediation conference is beneficial. If you're in a legal dispute, I always encourage a mediation conference because one of the things we'll give you, one of the first benefits that will give you is client control. You are in control of the mediation. If the matter resolves, it's because you decided to resolve it on your own terms. You made the decision that these are my terms, and obviously with the agreement of the other party, but the individuals who are involved in the litigation, the two parties, plaintiff and defendant, have made a decision to resolve the matter, and they were able to arrive at a compromise. That's the only time that the client has control of the process. Through litigation, you really don't have that much control. The attorneys and the judge control the process, and when you bring your legal matter to a judge, you're telling the judge, we really cannot solve it among ourselves. We need you to decide for us how to proceed. And I guarantee you the judge will decide what's going to happen, and there are no guarantees that you will be happy with that decision. Somebody's going to win, somebody's going to lose if you let the judge make a decision on your problem. In a mediation conference, you have client control, and you have that ability and the opportunity to resolve the problem on your own terms. Second benefit of mediation is cost control. The mediation, you have to pay the mediator, they range between $400 to $600 an hour, depending on the expertise, depending on the specialty area, depending on their experience. They're different, a wide range of rates for mediators. And usually the parties split that between in half. So, talking about a 4-hour mediation, it could cost you maybe $1,000 tops, and that range. Don't quote me on that. I just want to give you kind of an idea what a mediator will cost. And then obviously you got to pay your attorney's fees, whatever, for your attorney preparation, etc. But from a comparison perspective, when you're looking at a cost of a mediation versus the cost of litigation, it's a no-brainer. Mediation is a lot less costly than going all the way to litigation. And you have the opportunity at a mediation conference to really resolve the matter there at that point and shut down cost, control the cost, and perhaps eliminate future costs of litigation, because if it's resolved, you no longer have to litigate. So cost control is another benefit. Comfort. Mediation is an informal process, but there's some formalities, but it's more comfortable than being in a deposition, being a trial. So you'll have the opportunity to address the matter in a more comfortable setting. And that is important because you want to basically be as relaxed. You're going to be tensed anyway, but and stressed out, but you want to be as a more comfortable environment to really discuss the matter openly with the opportunity to get it resolved. Now, most of the mediations that I've done, in fact, all of them that I've done since COVID has been via Zoom. They're very effective. You can be at your home, you can be at your office, and they get resolved. And many of them get resolved that way. You also can have it in a conference room, in a mediation room, that you with your attorney, and then the mediator goes back and forth, and between the parties to try to see if they can arrive at a solution. Commitment. The objective of the mediation is to get a commitment. In my experience, when the parties that are in a legal dispute, in the business litigation context, which is what I focus on, concentrate on, when the parties spend 4 hours thinking how to resolve the problem, in my experience, even if it does not get settled at that moment, in that particular afternoon, because people get tired, They just don't want to keep talking about it, or just something is just not run out of time, just didn't work out. In my experience, in many cases, the matter gets resolved a few days later, simply because the focus of the business owner is about resolving the problem, not about litigating. And they begin to think about the things that they discussed during the mediation. And in most cases, in fact, every case that I've been in mediation, the mediator talks about the litigation cost. And that becomes a prime motivator to resolve the dispute. Courtesy. The mediations are basically, they're informal, but also they're respectful. And the objective is you'll have the opportunity here in a more open forum, in a confidential forum, to really speak up and to say you're part of the case in a non-adversarial manner. And vice versa. Sometimes it's good to hear the other side. And from an attorney's perspective, and I tell my client, this is the only opportunity that I have to speak directly to the other side with the attorney present. And they don't have to answer any questions or reply or agree with me. But that is my opportunity for them to get to meet me and know why I believe that we have a good case. And also an opportunity for them to listen to their position as well, because all I've heard is from the attorney's perspective. I have not heard from the party himself or herself. So, but it's a courtesy. It's a very courteous process, and it's a civil process. It's not designed to be confrontational. It's not designed to basically create animosity. So it's about, let's try to focus on resolving this dispute and get out of this litigation as soon as possible. Creativity. What I like about the business law and business litigation and what I do is that you really have a blank canvas to come up with creative solutions. Okay. Another point that I wanted to make is that it's about creativity. What I like about business litigation and business law is what I've been practicing in my entire career with the Florida Small Business Legal Center, my firm, is that you can be creative and you can come up with creative solutions to your problem. Sometimes it's about money, sometimes not about money. But we can be creative in how to craft a solution versus in a jury verdict, you have somebody's going to win money damages, somebody's going to have to pay money damages. There's no creativity there. When you go into court, you're asking for money, we're asking for injunctive relief. But as business lawyers, we can be creative and come up with a creative solution to a legal problem, working with you, the business owner. Confidentiality. Whatever you say in mediation, stays in mediation. And it's actually, no one can say anything about what happened at the mediation in a court proceeding, anywhere else. The objective is to encourage you on the other side to really talk freely and openly about how to resolve the problem. And nobody can basically ask the mediator to come and testify. Nobody can say, well, you said at the mediator that a mediation X, Y, and Z. Nobody can ask you that question. It's a confidential process. You arrive at a settlement. The settlement is confidential as well. The only thing that is filed in court is whether or not you arrived at a settlement or if the case has an impasse and the case did not settle. But whatever happens in mediation, stays in mediation. And the last benefit that I would like to share with you is compromise. The ability to compromise is very important. And once you arrive at a compromise, you'll have closure and peace of mind. You know, and pretty much in my career, I haven't had anyone tell me, I wish they did not settle that case. That the relief that they experience the next day after the matter has been resolved, whether a person is paying or receiving money, doesn't matter. But the psychological relief that the client experiences when the matter has been resolved is worth it. So I just want to share those with you because there are benefits of mediation, and obviously you can tell by my enthusiasm here is that I really believe in mediation. I solved many of them, done a few hundred of them in my career, and every case pretty much should go to mediation. At the very least, give it a shot. No guarantees. You're not obligated to settle the case, but you have an opportunity to possibly get that matter resolved, and you move on with your life. This chapter is closed. Okay, so now that I told you about what is a mediation, the benefits of mediation, I want to talk briefly about some of the mistakes, 5 mistakes that I see that attorneys make mediation, but also sometimes clients make in mediation. And these are all avoidable. So one of the ones I want to talk about is lack of preparation. I believe preparing for mediation is just as important as preparing for trial. I'll tell you why. You have to educate the mediator on the case. That's the only opportunity that I have to introduce myself to the other side, to the other party. And they're basically gauging, who am I dealing with? Who's the attorney on the other side? What are his skills? What are his ability? This is what I'm dealing with on the other side going to trial. So the better prepared you are for mediation, the better for you. Knowing the facts is essential, knowing everything about that case. So in the case they bring a point that you need to address, you have the facts at your fingertips. So preparation is important. My rule is before every mediation, I have a pre-mediation conference with the client that lasts between 45 minutes and an hour. We talk about the facts. We talk about strategy. We talk about tactics. We talk about goals. We talk about expectations. We talk about what we expect into the mediation. It's important to have that meeting. So the better prepared you are, the more likely you're going to be successful at that mediation in terms of getting it resolved. Number 2, another mistake that people make is unrealistic expectations. You have to be going to mediation knowing that you're going to go there with the possibility of compromise, that you will make a good faith effort in trying to resolve the matter. And for that, you'll have to compromise. And perhaps if you're the one seeking some money, you might receive less than what you're expecting. You're the one that has to pay. You might have to pay a little bit more than you were expecting. But it's all a decision that has to be made at the time when you have to allow the mediator to do his or her job. Mediator comes with a potential offer and how it is presented to you. But you got to be realistic about what to expect, or at the very least go with an open mind to see if you can get this matter resolved. Poor negotiation skills. Negotiation is an art, and that's a whole different topic of discussion that we can go into at another time. But the attorney that is representing you needs to be a good negotiator. And in my experience, a good negotiator listens. It's important to listen to the other side. It's important to understand where they're coming from to be able to negotiate. So, and it's not a simple skill to have. It comes with experience, practice, training, and preparation. So, poor negotiating skills from the attorney, or sometimes the client. The client is not going to be an expert negotiator. They don't do this every day. But the attorney should be a good negotiator to be successful at that mediation. Lack of patience, number 4. You go to mediations, you got to be patient. Sometimes mediations take about 4 hours, sometimes longer. I think that 4 to 6 hour mediation is plenty. That's my personal opinion. I've heard colleagues tell me they went to a mediation for 12 hours. Frankly, that's too long. I think, in my personal opinion, people get exhausted, people get tired. At a certain point, people get hungry, and obviously you can feed them, but there's a point of diminishing return with any negotiation. And too long of a negotiation, basically wearing somebody down. At some point, people just say yes just because they get tired. So you got to be patient, knowing that the other side might say things that you do not want to hear, that you do not agree with. They might give you offers that are very low that you don't like. And usually the first offer is a low ball anyway. But be patient and allow the process to continue. Allow the process to evolve. Let the mediator do his or her job. Let the process. Believe in the process and something might happen. Last but not least, inadequate technology. A lot of mediations are via Zoom. So when the mediation is via Zoom, what I ask my clients to do, we're going to do the pre-mediation conference with the practice run with me, and we're going to do it in the exact same location that the client is going to be located at. We're using the same technology that they will be using. So we can see the technology working. If your Wi-Fi is weak, if I cannot hear you, I cannot see you well, it is important that we don't have those technological challenges at the mediation conference, because if you have a problem connecting online to your Zoom or to video conference, and that's going to eat up mediation time, it's just become a stressor. So we can reduce the stressors to just make sure technology works well. So just to recap, number one, lack of preparation. Number two, unrealistic expectations. 3, poor negotiation skills. 4, lack of patience. 5, inadequate technology. So next time you're in a mediation conference, hopefully this was helpful to you. If you have any questions, you'd like to reach me, you would like to talk about any of these topics, you can reach me at rich@richsierra.com. My website is floridasmallbusinesslegalcenter.com. If you'd like to subscribe to our YouTube channel, it's youtube.com/@RichardSierra. If you like the show, please subscribe and follow us and give us a 5-star review. Certainly appreciate that. And you want to reach me, my number is 866-842-5202. Again, this is Rich Sierra. Until next week, remember that my goal is to help you succeed.